was allowed by law to do anything that would bring that process to fruition. In that regard, we are guided by the provisions of Article 259, Subarticle 3A and B, which stipulates as follows, and I'll quote that section: "Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, a function or power conferred by this Constitution on an office may be performed or exercised as occasion requires by the person holding the office. Any reference to this Constitution to a state or other public office or officer or a person holding such an office includes reference to the person acting in or otherwise performing the functions of the office at that particular time." From the above analysis, we find that although the Speaker of the County Assembly, while acting as a governor under Article 182, Subarticle 5 of the Constitution, has no power to appoint a deputy governor, the peculiar circumstances of this case entitle the Speaker of Nairobi City County Assembly to complete the ongoing process of appointment of Anne Kananu as deputy governor. The process had been stopped by the court in the Peter Agoro case, and it is the same court which vacated the conservatory orders, hence allowing the process to proceed to its legitimate and logical conclusion. Had Anne Kananu not been approved by the county assembly, the gubernatorial by-election would then have been held. There were other issues which we considered, starting with the argument by some of the parties that the gubernatorial election, having not been held within 60 days from the date of the impeachment of Hon Sonko by the Senate, no election can now be held as it had been overtaken by events. There was a contrary position taken by the IEBC to the effect that a conservatory order only freezes time and cannot be equated to expansion of constitutional timelines. Interestingly, all the parties relied on the same case, which was the case of George Michael Wanjohi, to advance their competing positions. In view of our findings herein above, this issue no longer requires our extensive analysis. Nevertheless, our brief answer to the question is found in the George Michael case, where the Supreme Court held, and I quote, "Consequently, any statutory process or act done will traverse the provisions of the Constitution. This court will not hesitate to declare them void. Hence, a stay order will not be tantamount to stopping a constitutional process." I'll end the quote there. We therefore agree with the IEBC's position that a court's order staying the occurrence of a constitutional event does not amount to a breach of the constitutional timelines. We cannot imagine a situation where an event ordained by the Constitution will not occur simply because it has been postponed. Another issue was the request by the 7th and 8th interested parties for this court to expunge any reference to them in Hon Sonko's pleadings. This request is indeed available under Order 2, Rule 15, and Order 19, Rule 6 of the Civil Procedure Rules. We have in this judgment already made our determination regarding the veracity of Hon Sonko's pleadings and averments over this issue. Our view is that the averments and pleadings of Hon Sonko conveyed his case as he perceived it. The power to strike out pleadings and averments should be exercised cautiously, lest the right to access justice is interfered with. Our determination that Hon Sonko's pleadings in relation to the 7th and 8th interested parties are unbelievable is sufficient protection of their right to correction and deletion of untrue or misleading information. Any infringement of the right to privacy can be pursued through other processes or litigation. Regarding the issue as to whether the IEBC violated the law by publishing gazette notice calling for by-election for the position of governor of Nairobi City County, we do find that the action of the IEBC are a direct consequence of the letter from the Speaker of the County Assembly informing the Commission of the vacancies in the offices of the Governor and Deputy Governor. We observe that as at the time of the impeachment of the Governor, the process of appointment of the nominated deputy had been stayed by a court, but was soon thereafter reactivated. It is therefore our finding that the IEBC cannot be faulted for calling for the by-election. As we have already stated in this judgment, a by-election would have indeed been conducted if Anne Kananu had not been approved by the County Assembly. Before we leave this issue, we find that an order of certiorari quashing the Gazette notice is no longer necessary in view of our findings. So, having regards to the above analysis, it is our finding that the nomination, vetting, approval, and swearing in of Anne Kananu as the Deputy Governor was constitutional and complied with the applicable laws. Consequently, we find that all the petitions challenging her ascendancy to the position of Deputy Governor are without merit and are hereby dismissed. Conversely, our above holding is sufficient to take care of the prayers in Anne Kananu's cross petition and that of the fourth petitioner, Josephat Kariuki. On costs, the general rule as provided under Section 27 of the Civil Procedure Act is that costs ordinarily follow the event unless for good reason the court orders otherwise. The consolidated petitions are in respect of a novel issue concerning the governance of county governments. The appropriate order in the circumstances is to direct each party to bear their own costs. Before we sign off, we take this opportunity to appreciate the parties and their advocates for their industry and research in this matter. These are the orders of the court.
Most obliged, my lady.
Most obliged, my lady, my lord.
We have the first party, my lady, my lord. This is Harrison to request for the certified copies of the proceedings and the judgment.
The third interested party, Katiba Institute, joins in that request.
Your Lordship, also on behalf of the 10th interested party, Short Munguko also wishes to apply for the proceedings and also a copy of the judgment.
Also, the 10th petitioner wishes to apply for proceedings and a copy of the judgment.
My Lord, the eighth and ninth petitioner also wish to ask for a copy of the proceedings and the judgment.
Your Lordship, also for the third petitioner, we wish to request for copies of the same.
So, copies of certified proceedings and judgment to be supplied as prayed to all the parties who shall ask for them upon payment of the requisite fee. There was somebody talking?
Okay. My Lord, given that copies of judgment are not immediately available, and given that the court indicated that the same will be available at the earliest on Monday, my Lord, parties may be inclined to challenge the decision of the court, yet they may not be. They may not have.
Mr. Nyamu, sorry for cutting you short.